Hi there, my name is Glenn Blackett. I am a lawyer with the Justice Center for Constitutional Freedom's network of lawyers, and I'm providing a quick update on the Francis Widdowson, Jonah Pickle versus University of Lethbridge file. So I was at the Court of Appeal on Monday of this week on a procedural issue that came up, but I think there's two very important constitutional aspects to that you should know about. So the first one is this. What got me there was that, first of all, a little background. The University of Lethbridge canceled a free speech event that was going to feature Francis Widdowson on the theory that Francis Widdowson's presence on campus, mere presence on campus, posed basically a psychological risk to students and especially to Indigenous students. And because of the psychological risk, they deemed that they had to cancel the event. And I guess obviously, given that her mere proximity was what caused these psychological risks, the only way to resolve that would be to ensure that she just doesn't come on to campus. Now, she did come onto campus for something else, but that's a detail that we needn't talk about here. Nonetheless, so when we got their defense in October of 2024, they said, well, one of the reasons we had to cancel is because a statute called the Occupational Health and Safety Act obligates us to ensure the mental health of people on campus. So that sounds like a stretch. Surely the Occupational Health and Safety Act doesn't say that. Well, no. The Occupational Health and Safety Act does, in fact, if you look at it, and has since about 2017, required that employers, every employer in the province, ensure that their place of employment is a mentally safe space. And I hope you understand what I mean by safe space. What it tends to mean is a place where, let's say, heterodox opinions aren't permitted, because heterodox opinions might cause a person to feel uncomfortable, might cause a person to be upset, or might cause them, quote unquote, a psychological injury of some sort. So since 2017, there have been these obligations in the Occupational Health and Safety Act, which are clear and obvious infringements on expressive rights. I'm surprised that I haven't heard more about these provisions, because I've seen these provisions pop up on a lot of files. And justifying all sorts of, I think, pretty draconian conduct on the part of the state and on the part of private enterprises. So these safe spaces requirement under the Occupational Health and Safety Act are a real problem. That's one thing that brought me to the Court of Appeal. The other thing that brought me to the Court of Appeal was a little procedural problem I had, which is another very interesting element to this case. When the University of Lethbridge said, hey, we have the statutory obligation to censor, we said, okay, well, if that's the case, then we'd like to challenge the constitutionality of that statutory obligation. The university refused to allow that to happen, so we had to go to court to ask the court to allow that. The court didn't allow it. Now, I could take a long time to dismantle what I think were the errors in that decision, but the primary concept there seemed to be that, well, because the statute is worded in a general way, and there's lots of different ways for an employer to satisfy the obligation to ensure that certain expression doesn't occur on their work site, then there was really no way for a citizen to challenge those provisions as being a violation of the Constitution. That's pretty incredible. What it would mean is that as long as a government passes legislation, including some kind of draconian requirement on private individuals to suppress expression or express other constitutional rights, the theory would be, as long as the statute is worded generally enough, then it's immune from the Constitution, which cannot be right. It just cannot be right. That's in my opinion, just an absolute blanket denial of access to justice. And is also, I would say, contrary to the case law. The case law indicates that the more vague and fuzzy you get when you have these requirements by the state that infringe constitutional rights, the less defensible they become. If you want to infringe constitutional rights as a government, you have to do it in clear and narrow terms. If you do it in vague and general and loosey terms, that becomes less defensible under the charter to allow, and in part because what happens is it creates a chilling effect where people are scared of infringing the the statute. They don't know exactly what they have to do, so they just take extra precaution. They stay an extra wide distance from any kind of an infringement, which actually causes a greater number of constitutional infringements rather than fewer. So those are the two issues that we had at the Court of Appeal on Monday. We asked them to overturn the lower court ruling and allow us to file that amendment so that we can take a run at the Occupational Health and Safety Act. And the three justices on the panel have reserved, and we'll update you again when we get a decision. Thanks very much. Bye.